Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the nation. Here are the headlines. Day 3 of the Supreme Court hearing the plea challenging abrogation of Article 370. Supreme Court refuses to entertain plea challenging bail granted to person who issued tickets the day Morbi Bridge collapsed. Punjab and Haryana High Court take suo moto cognizance of demolition of buildings in Nuh and Gurugram without proper orders and notice. After Lok Sabha, Delhi Services Bill also passed by Rajya Sabha. Wife calling husband dark-skinned amounts to cruelty, rules Karnataka High Court. Now let's take a detailed look at the headlines. A 5-judge constitution bench of the Supreme Court, comprising the Chief Justice of India D.Y. Chandrachud and Justices S.K. Kaul, Sanjeev Khanna, B.R. Gavai and Suryakant, continued hearing the batch of pleas challenging the abrogation of Article 370. The Apex Court is hearing over 20 petitions pending before it that oppose the decision of the central government made in the year 2019. The hearing in the matter began on a day-to-day basis on August 2nd. And the court has so far examined questions as to whether Article 370 was envisaged as a permanent provision because the Jammu and Kashmir Constituent Assembly, empowered to recommend the deletion of the provision, had ceased to exist in 1957. And whether Article 370 would become part of the basic structure of the Constitution if it is accepted that Article 370 became permanent when the Constituent Assembly of Jammu and Kashmir was dissolved in 1957. Today, the arguments were commenced by senior advocate Kapil Sibal, who posed the question whether the Constitution of India be decimated by an executive act. The CJI D.Y. Chandrachud remarked, if we accept that Article 368 is used for amending all articles, then Article 370 will also be covered. Then the argument that there is no power to amend can be a moral argument, but not a legal one. Mr. Sibal contended that the inception of the executive order was constitutionally flawed. He also highlighted that there would have been no Constitution of Jammu and Kashmir if Article 370 was to be abrogated. He also made several references to the Brexit exercise that was conducted in the UK. The CJI also talked about Brexit briefly, stating that it was a political decision, but in a constitution like ours, there is no question of referendum. The CJI also questioned the need to amend Article 367 in order to abrogate Article 370. A 3-judge bench of the Supreme Court comprising the CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Mishra refused to entertain a plea challenging the bail granted to the person who issued tickets the day Morbi Bridge in Gujarat collapsed. The bail was granted by the High Court of Gujarat to Mansukh Bhai Topia, who was responsible for issuing tickets on October 30th last year, the day the Morbi Bridge collapse occurred. The top court said that they were not inclined to entertain the special leave petition filed by Tragedy Victim Association Morbi, as the High Court was of the opinion that judicial custody of the accused was not required. The counsel for the accused highlighted that the accused jumped in the river to save people and himself suffered injuries. The state, however, opposed the plea, stating that his negligence played a vital role in the incident, which led to the death of about 135 people. The High Court had observed that the trial will take its own time to conclude, and the presence of the accused was not required, while granting him regular bail. The Punjab and Haryana High Court bench, comprising Justices G.S. Sandhawalia and Harpreet Kaur Jeevan, while relying on news reports, took suo moto cognizance of incidents of demolition of buildings in Haryana's Nuh and Gurugram, after the areas witnessed communal clashes recently. The court passed an order dated August 7th, stating that the demolition drive is being conducted without any demolition orders and notices. The law and order problem is being used as a ruse to bring down buildings without following the procedure established by law. The court further questioned whether the buildings belonging to a particular community are being brought down, and an exercise of ethnic cleansing is being conducted by the state. The court had also taken a suo moto cognizance and halted the demolition drive conducted by the state government in Nuh district. The matter is scheduled for next hearing on August 11th. The Rajya Sabha passed the Government of National Capital Territory of Delhi Amendment Bill, also known as the Delhi Services Bill, after the same was cleared by the Lok Sabha 4 days ago. The bill received 131 votes in favor and 102 votes against it, and is set to replace the ordinance on the transfers and postings of senior officials in the Delhi government. Union Home Minister Amit Shah said that the bill does not in any way violate the May 11th verdict of the Supreme Court that granted the power with regards transfers and postings of officials in Delhi, including the Indian Administrative Services, except those pertaining to land, police and law and order. The top court had unanimously held that the Lieutenant Governor of Delhi would be bound by the decisions of the Aam Aadmi Party-led Delhi government over services other than land, police and law and order. Justice Ranjan Gogoi, the former Chief Justice of India and now a nominated member of Rajya Sabha, also participated in the discussion on the bill and said that the bill does not overreach the judgment of the Apex Court and that by virtue of Article 239AA of the Constitution of India, Parliament has the power to make laws for the NCT of Delhi. The High Court of Karnataka held that a wife calling her husband dark-skinned and insulting and demeaning him due to his skin color amounts to cruelty. The division bench of the High Court, comprising Justices Alok Aradhe and Anant Ramanathan Hegde, made the observation while granting divorce to a couple. The court noted that the wife used to insult the husband on the premise of his dark skin color and had moved away from the company of her husband for the same reason. To cover this up, she leveled allegations of illicit relationships against the husband. These facts certainly constitute cruelty, the High Court said, while allowing the dissolution of marriage filed under Section 13(1)(a) of the Hindu Marriage Act. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.